If you're planning to come to the United States already living here on a visa or waiting for your green card, you need to stop what you're doing and pay attention right now. The U.S. immigration system has undergone dramatic transformations in 2025 that are affecting millions of people worldwide. From unprecedented fee increases to major policy shifts, from the end of popular humanitarian programs to sweeping enforcement changes, what's happening right now will directly impact your immigration journey. I'm going to break down everything you need to know in the next few minutes, so stay with me until the very end. Welcome back to Move to USA, your trusted source for accurate, timely immigration information. I'm here to cut through the confusion and give you the facts you need to make informed decisions about your future in America. In this video, we're covering the real immigration changes that have happened in 2025 and what's coming in 2026. These aren't rumors or speculation. These are actual policy changes, executive orders, and legislation that have already been signed into law. Whether you're on an H-1B visa, waiting for a green card, seeking asylum, studying in the U.S., or planning to immigrate with your family, this information is critical for you. Let's dive in. The One Big Beautiful Bill Act. What actually passed? Let's start with the most significant legislative change, the One Big Beautiful Bill Act, officially known as H.R. 1. President Trump signed this into law on July 4th, 2025. This is real legislation that passed through Congress using a process called budget reconciliation, which allowed it to pass with just 51 votes in the Senate instead of the usual 60. Now, it's crucial to understand what this bill actually is. This is not comprehensive immigration reform. This is primarily a budget and tax bill that includes substantial immigration-related provisions, particularly around funding and fees. Let me be very clear about what changed and what didn't. The bill allocated approximately $170 billion over 4 years for immigration enforcement and border security. This is an unprecedented amount of funding. To put this in perspective, this represents more than 4 times the current annual budget of Customs and Border Protection. Here's where that money is going. $45 billion has been allocated for immigration detention facilities, including family detention centers. This represents a 308% increase in ICE's detention budget compared to 2024. The funding will support detention capacity for potentially 116,000 beds, with significant portions going to both existing facilities and new tent-based detention camps. $75 billion is designated for immigration and customs enforcement to expand interior enforcement operations. This includes hiring 10,000 additional ICE officers and agents over the next several years with specific hiring targets. 2,500 in fiscal year 2025 and 1,875 each year through 2029. There's also funding for retention bonuses, equipment, and transportation for removal operations. Approximately $60 billion goes to Customs and Border Protection for personnel, technology, vehicles, and facilities. This includes $4.1 billion to hire and train new Border Patrol agents, over $2 billion in retention and hiring bonuses, and $6.2 billion for border security technology, including artificial intelligence, biometric entry and exit systems, and non-intrusive inspection equipment. The bill also provides $12 billion for reimbursing states and localities for border security activities. This is particularly significant because it's expected to reimburse states like Texas for their own immigration enforcement programs. Massive FE increases the financial burden. One of the most immediate and impactful changes from H.R. 1 is the dramatic increase in immigration fees. These new fees went into effect on July 22, 2025. Let me walk you through the major changes because these will directly affect your wallet. For asylum applicants, there's now a $100 filing fee just to submit your application. Historically, asylum applications have never required a filing fee because asylum is a humanitarian protection for people fleeing persecution. But now there's not only an initial fee, but also an additional $100 annual fee for every year your asylum application remains pending. Given that asylum cases can take years to process, this can add up to hundreds or even thousands of dollars. Employment authorization documents, or EADs, for asylum applicants, parolees, and TPS beneficiaries now cost $550, up from $470 for online applications. This is just for the initial authorization. Renewals cost $275. For people granted humanitarian parole, There's now a $1,000 fee to apply, plus $550 for initial work authorization and $275 for renewals. And here's the critical part. There are no fee waivers available for these applications. None. This means even if you cannot afford these fees, you still have to pay them. Temporary protected status registration fees have jumped from $50 to $500, with the same increased fees for work authorization. Advanced parole applications, which allow non-citizens to travel outside the U.S. and return, now cost $1,000, up from $630. Immigration court fees have also increased dramatically. Appealing an immigration judge's decision to the Board of Immigration Appeals now costs $900, up from $110. That's more than an 800% increase. There are new fees that didn't exist before. If you're removed in absentia, meaning you didn't appear for your immigration court hearing, there's now a $5,000 apprehension fee. If you're apprehended between ports of entry, that's another $5,000 fee. And here's something many people don't realize. All of these fees are indexed to inflation. This means they will automatically increase every single year. In fact, the Department of Homeland Security already announced the fiscal year 2026 inflation adjustments in November 2025. For example, the ESTA fee increased, the parole fee increased, and the EVUS fee increased based on the Consumer Price Index. The H-1B visa overhaul fundamental changes. If you're in tech, healthcare, or any field that relies on H-1B visas, this section is critical for you. In September 2025, the Department of Homeland Security unveiled a major proposal to change how H-1B visas are awarded. Currently, H-1B visas are allocated through a random lottery system. The new proposal changes this to a merit-based system that prioritizes higher-skilled and higher-paid positions. The goal, according to USCIS, is to prevent employers from using the H-1B program to bring in foreign workers at lower wages than they would pay American workers. Under the new system, H-1B petitions will be evaluated and ranked based on factors like offered salary and job requirements. Higher-paying positions requiring advanced skills will get priority. This is designed to ensure that H-1B visas go to the most highly skilled workers rather than being distributed randomly. But here's the bombshell. In September 2025, President Trump signed an executive order introducing a $100,000 fee for H-1B visas. Yes, you read that correctly, $100,000. This fee is in addition to all the other costs associated with the H-1B petition. Now, legally, employers cannot pass this cost to the employee. The employer must pay it. But this creates enormous financial pressure on companies, particularly smaller businesses that cannot afford to pay an additional $100,000 per worker. Many immigration attorneys have already filed legal challenges to this fee, arguing that the president lacks the authority to impose such a fee through executive order alone. The H-4 visa category, which allows spouses of H-1B workers to come to the United States, has also faced restrictions on employment authorization. This has created significant hardship for H-1B families who relied on dual incomes. In December 2025, President Trump announced the launch of the Trump Gold Card program. This is a visa program that provides a pathway to permanent residency and eventual U.S. citizenship in exchange for a $1 million investment in the United States. This is essentially a revamped and rebranded version of the EB-5 Investor Immigrant Visa Program, but with streamlined processing. The program is designed to attract wealthy foreign nationals who can make substantial financial investments in the U.S. economy. Details are still being finalized, but the program is expected to launch in early 2026 with specific investment requirements, job creation obligations, and processing timelines that differ from the traditional EB-5 program. Humanitarian programs, massive terminations. This is where some of the most dramatic changes have occurred, affecting over 1.6 million people. Let me break this down by program. The CBP-1 app, which was created during the Biden administration to allow migrants to schedule appointments to enter the United States and apply for asylum, was shut down on day one of Trump's second presidency, January 20, 2025. From 2023 to January 2025, more than 936,000 people used this app to gain legal entry. That pathway is now completely closed. Humanitarian parole programs, which allowed people from certain countries to come to the United States temporarily for urgent humanitarian reasons, have been ended or severely restricted. This includes the processes for Cubans, Haitians, Nicaraguans, and Venezuelans, known as CHNV. On May 30th, 2025, the Supreme Court allowed the Trump administration to end parole status for people who came through these programs. If you had CHNV parole, your status ended on May 30th, 2025. The Uniting for Ukraine program was initially paused and later resumed with modifications, but remains under threat of termination. CAM parole for Central American minors and family reunification parole programs have also been suspended. USCIS stopped accepting Form I-134A applications, which were required for many of these humanitarian parole programs. Temporary Protected Status, or TPS, has seen unprecedented terminations. TPS is a program that allows people from designated countries experiencing armed conflict, natural disasters, or other extraordinary conditions to live and work in the United States temporarily. The Trump administration has terminated or announced plans to terminate TPS for multiple countries. This includes Venezuela, Haiti, El Salvador, and others. When a country's TPS designation is terminated, people from that country typically receive 60 days' notice to leave the United States voluntarily with a $1,000 cash payment offered as an incentive or face deportation. If TPS designations for El Salvador, Lebanon, Somalia, Sudan, Yemen, and Ukraine are not renewed when they expire, the United States may have no one residing under TPS for the first time since the program was created in 1990. The Refugee Resettlement Program was suspended for 90 days, starting on the first day of Trump's second term. During this suspension, USCIS was ordered to review all refugees admitted under the Biden administration. Secretary of Homeland Security was directed to determine whether resuming the program would be beneficial to the United States even after the 90-day period. Refugee admissions remain at historically low levels, with only case-by-case exceptions for refugees deemed not to pose a threat and whose admission is considered in the U.S. interest. Citizenship harder to achieve. For those seeking to become U.S. citizens, the path has become more challenging. USCIS has made several significant changes to the naturalization process. The civics test has been modified. If you filed your N-400 application for naturalization on or after October 20th, 2025, you will take a new, more difficult version of the test. The number of possible questions has increased, and the number of questions you must answer correctly has also increased. The good moral character requirement is being interpreted more strictly. Immigration officers are now considering additional factors when determining whether citizenship applicants have good moral character. This includes increased scrutiny of tax compliance, past immigration violations, even minor criminal history, and public benefits usage. Citizenship application denials have increased by 24% under the new administration. Processing times have also gotten longer despite promises to the contrary. The government has announced plans to increase denaturalization efforts. USCIS field offices are expected to refer 100 to 200 denaturalization cases per month for legal review. While the stated focus is on people accused of fraud when they applied for citizenship, this represents a significant escalation in efforts to strip people of citizenship after it's been granted. For green card holders applying for citizenship, the window of vulnerability has expanded. Any issues in your immigration history, tax history, or criminal history, even if resolved years ago, may be scrutinized more carefully during the naturalization process. Green card holders, new requirements, and risks. If you're a lawful permanent resident, you're probably wondering how all of this affects you. The good news is that the changes don't retroactively strip anyone of green card status. Your green card remains valid. However, there are important changes to how you must maintain that status. Enhanced screening at ports of entry is now standard for green card holders returning from international travel. CBP officers are conducting more thorough reviews of travel history, employment status, tax compliance, and ties to the United States. They have broader authority to refer cases for additional review if there are questions about whether you've abandoned your permanent residence. There are new reporting requirements for permanent residents. Green card holders must report address changes within 10 days of moving. Some categories of green card holders must report employer changes. Importantly, you must report any criminal arrests, even if charges are ultimately dismissed or you're found not guilty. Enforcement, a more aggressive posture. Perhaps the most visible changes have been in immigration enforcement. USCIS, under Director Joseph Edlow, has explicitly stated that at its core, USCIS must be an immigration enforcement agency. This represents a fundamental shift for an agency that traditionally focused on processing applications for people seeking to lawfully immigrate and stay in the United States. The agency has created a new position called Homeland Defenders. Since launching the hiring campaign on September 30th, 2025, USCIS has received more than 50,000 applications, the highest in agency history. The first Homeland Defenders began reporting for duty in early December 2025. These positions are focused on combating fraud and supporting enforcement activities. CES violate the Privacy Act of 1974. What happened to DACA? The status of DACA, or Deferred Action for Childhood Arrivals, remains uncertain. While the current administration continues to challenge the program in court, here's what we know. As of February 2026, renewals remain open. People with DACA can still renew their protections, work permits, and advance parole documents for travel. First-time applications are not being processed, even though courts have indicated they should be. DACA recipients in Texas face particular uncertainty after court rulings suggested they may lose certain benefits, though further instructions are still pending. The future of DACA depends heavily on ongoing litigation and potential legislative action. The diversity visa lottery paused indefinitely following the Brown University shooting in 2025, where the alleged perpetrator had entered the U.S. through the diversity visa lottery program in 2017. Homeland Security Secretary Kristi Noem announced that the program would be paused. The State Department tweeted on November 5, 2025, that it's implementing certain undisclosed changes to the upcoming diversity visa entry process and will announce the start date for DV 2027 registration when ready. As of February 2026, no new timeline has been announced, and it's unclear when or if the program will resume. This affects people from countries with historically low immigration rates to the United States, who rely on the diversity lottery as their only realistic pathway to a green card. Changes to USCIS operations and culture. Beyond specific policies, the culture and operations of USCIS have fundamentally changed. Signs inside USCIS offices now urge people to leave the country. According to immigration attorneys, this creates an adversarial atmosphere more reminiscent of a detention center than an immigration services office. The agency encouraged early retirements among staff, shut down collective bargaining agreements with unions, and has seen significant departures. At least 130 people took the fork in the road resignation offer for federal employees, while others have left independently. Morale inside USCIS has reportedly plummeted. Current and former employees describe an agency being transformed from one focused on lawful immigration into one primarily focused on enforcement and deterrence. All refugees admitted during the Biden era must be re-interviewed, creating enormous backlogs and delays. Employees describe this requirement as impossible and expect it to cause chaos and confusion while costing substantial amounts of money. The agency has paused approvals for certain country nationals while working to ensure enhanced vetting and screening procedures are in place. Processing times for many applications have actually increased, despite promises of faster service, as resources are redirected to enforcement activities and priority categories. What does all this mean for you? Now, let's get practical. What should you actually do with all this information? First, if you have any immigration application pending or if you're planning to file anything, do not delay. Policies are changing rapidly, and what's available today may not be available tomorrow. Processing times are getting longer, not shorter. Despite agency claims, file as soon as you're eligible and can properly prepare your application. Second, document everything. Keep copies of all your immigration documents, entry and exit records, pay stubs, tax returns, lease agreements, anything that shows your ties to the United States and your compliance with immigration law. You may need these documents at any time, whether for a port of entry inspection, a status review, or a future application. Third, be extremely careful about travel if you're a green card holder or on a temporary visa. Understand the rules for maintaining your status. Green card holders should not spend more than 6 months outside the U.S. without careful planning. If you must be outside for an extended period, consider getting a re-entry permit before you leave. Visa holders should ensure they have valid documents before traveling and understand the risks of denied re-entry. Fourth, stay informed through official sources only. Rely on information from us.gov, travel.state.gov, and official government announcements. Do not make decisions based on social media posts, rumors, or secondhand reports. When regulations are published, they appear in the Federal Register. When policy changes are announced, they're posted on official government websites. Fifth, and this is crucial, consult with a qualified immigration attorney if your case has any complexity whatsoever. The stakes are higher than they've ever been. The margin for error has shrunk. Requirements are more stringent, and consequences of mistakes are more severe. This is not the time for DIY immigration applications. If you have criminal history, prior immigration violations, employment complications, conditional residence, or time-sensitive applications, you absolutely need professional legal guidance. Sixth, if you're eligible for naturalization, seriously consider applying now. Citizens have protections that green card holders don't have. While the naturalization process has become more challenging, citizenship cannot be easily revoked once obtained, except in cases of fraud. If you meet the requirements, don't wait. Seventh, understand your rights. If ICE comes to your home, you have the right to remain silent and the right to an attorney. You don't have to open the door unless they have a warrant signed by a judge. If they have an administrative warrant from ICE or CBP, that's different from a judicial warrant. Know the difference. Carry documentation showing your legal status at all times. Eighth, prepare financially. Immigration is becoming more expensive across the board. The fee increases that took effect in July 2025 are just the beginning. Fees will increase every year due to inflation indexing. Budget accordingly if you have renewals, adjustments of status, or naturalization applications coming up. What's coming in 2026 and beyond? Looking ahead, we can expect continued policy changes and legal battles. Multiple lawsuits challenging various provisions of H.R. 1 and the executive orders are working their way through federal courts. Some provisions may be delayed or modified based on court rulings. The administration has indicated it will continue to restrict legal immigration pathways while increasing enforcement. We can expect more programs to be ended or modified, more fees to be imposed, and more stringent requirements across all categories. Congress may attempt to pass additional legislation, though given the narrow margins in both chambers, major legislative changes beyond budget reconciliation bills will be difficult. International relations will play a role. Countries that don't cooperate with U.S. immigration enforcement face potential visa restrictions and sanctions. This could affect citizens of countries that refuse to accept deportees or don't provide adequate identity verification. The election cycle in 2026 may influence some policies, particularly if control of Congress changes. However, many of the changes implemented through executive action and H.R. 1 will remain in effect regardless. I know this is a lot of information and I know it's overwhelming. The U.S. immigration system has undergone more dramatic changes in the past year than in any period since the 1990s. But here's what I want you to take away from this video. Change does not mean the end of opportunity. Yes, the path is harder. Yes, the requirements are more stringent. Yes, the costs are higher. But people are still getting green cards. Families are still being reunited. Skilled workers are still finding pathways to the United States. It's just more challenging now. The most important thing you can do is stay informed with accurate information, not panic based on rumors or fear. Make decisions based on facts from official sources and qualified attorneys, not social media posts. Take action on what you can control. If you need to file an application, file it properly with professional help if needed. If you need to document your status, do it now. If you're eligible for a benefit or protection, apply for it before policies change further. Remember, you're not alone in this. Millions of people are navigating these same challenges. Immigration attorneys, advocacy organizations, and community support networks exist. Use them. If this video helped you understand what's really happening with U.S. immigration in 2025 and 2026, please give it a like and subscribe to Move to USA. Hit that notification bell because immigration policy is changing rapidly, and you need to stay updated with accurate information. Drop a comment below and tell me how these changes are affecting you. What immigration category are you in? What questions do you still have? I read every comment and use your feedback to create content that addresses the issues you care about most. Share this video with anyone in your community who needs accurate immigration information. Knowledge is power, especially in times of uncertainty. Thank you for watching Move to USA. Stay informed, stay prepared, and stay hopeful. I'll see you in the next video with more updates as this situation continues to evolve. Take care.